Hello everyone, welcome to the Legal Aid ACT College Talk. I am Karan Sindhu. I am a Legal Aid ACT College lawyer. Legal Aid ACT respectfully acknowledges the traditional landowners, the Nanawal and Nambree people, whose land we are working on today, and pay our respect to elders past and present. We also acknowledge and pay our respects to the Aboriginal people who draw their ancestral lines from this land. In this workshop today, we will discuss the laws around vapes in the ACT. Vapes or electronic cigarettes are battery-operated devices that work by heating a liquid to create a mist that is inhaled. An e-cigarette or vape contains a cartridge or a tank that is filled with e-liquid. The e-liquids used in vapes may or may not contain nicotine. The sale, purchase, importation, use and advertising of e-cigarettes is covered both by Commonwealth legislation and ACT legislation. Under the Commonwealth legislation, e-cigarettes and e-liquids that contain nicotine cannot legally be bought from retailers in Australia, but can be purchased for personal use under the Medicines, Poisons and Therapeutic Goods Act of 2008. Vapes containing nicotine cannot be sold for commercial purposes in Australia without specific approval, authorization or license, as nicotine is considered a Schedule 7 dangerous poison under the Commonwealth Poison Standards. Even though the TGA has approved nicotine as an ingredient in tobacco, and there are nicotine replacement therapies such as nicotine patches, gum, lozenges, and strips on the register of therapeutic goods, vapes are not. Therefore, vapes that contain nicotine cannot be legally imported, exported, manufactured, or supplied for commercial purposes in Australia. Nicotine-containing vapes are only legally available to people with a prescription from a medical practitioner for therapeutic use. The prescription should state that vape is to be used to quit smoking or help with nicotine withdrawal. Within Australia, these are available to people with prescriptions from compounding pharmacies. If anyone wishes to import these in Australia, they need to have a medical prescription from a GP. However, there are some limitations to this. For example, a supply of only 3 months can be imported at a time. It is also important to note that since the industry is not regulated, the quality of personal vaporizers cannot be guaranteed by the government. ACT is one of the few regions in Australia where vapes are regulated in the same way as tobacco and herbal products. Vapes are referred to as smoking products in all ACT legislation. Because of this amendment, the same laws that apply to other smoking products like cigarettes apply to personal vaporizers. Vapes and liquids that do not contain nicotine can be sold and bought in the ACT through retailers who hold a tobacco license. They cannot, however, be labeled or advertised as nicotine replacement therapy or something people might use to quit or cut down their smoking. In the ACT, it is also an offense to sell vapes to anyone under the age of 18, and it is also illegal to purchase vapes on behalf of someone who is under the age of 18. Both of these offenses come with hefty fine and penalties. In the ACT, some places are classified as smoke-free zones, which means that vapes cannot be used in those premises regardless of whether they have nicotine in them or not. As I mentioned before, since vapes are classified as smoking products in the ACT, the limitations on where they can and cannot be used are the same as they are for other tobacco products. In the ACT, vapes cannot be used in enclosed public spaces, in outdoor eating or drinking places that are not designated outdoor smoking areas, in vehicles if there is a child under the age of 16 present, at underage functions, and at declared smoke-free public places or events. A person can receive a maximum penalty of $800 if they use a personal vaporizer in an enclosed public space. Under the legislation, a public place means a place where the public or a section of the public has access. The access can be by payment, by membership, or by entitlement or permission. Public places may also be defined as a business premises, a cinema, a theater, a club, hotel or a motel, a community center, a public library, government premises, a hostel or a nursing home, a place of worship, public transportation including a bus, a taxi or a boat, a restaurant or cafeteria. It can be a school, a college or a university, and even shopping centers. Vaping on grounds of all A-City public schools and colleges is also not permitted as per the smoke-free workplace policy of the A-City Department of Education and Training. Vaping is not permitted on all premises and adjacent grounds which are managed by the department. Vaping is not permitted in enclosed spaces, open places such as ovals and car parks within the identified site boundaries of premises solely managed by the department. Under this policy, if a student is found smoking on school grounds, they will be counseled and have their parents or carers informed about the incident. The school will also implement an appropriate discipline action. If you would like to speak with us about laws surrounding smoking or vaping, or would just like to have a confidential conversation so we can assist you with making a decision about your school, work or home life before you approach a well-being officer, teacher or other supports, please contact us for an appointment by emailing college@legalaid.act.org.au or calling 1300 654 314. I am also present on campus fortnightly.